Thank you very much, Josh. It's really a pleasure to be here. Trinidad was my home for 5 years, between 1983 and 1988, so I feel at home. I see in the audience two of my colleagues, Sinath Jairam, Senior Counsel, President of the Trinidad and Tobago Law Society, Reggie Moore. We went to school together. Alejandro Salas, our Regional Director of Transparency International, Derek, the Chair of TTTI, and his fellow board members, distinguished presenters, distinguished guests, ladies and gentlemen. In a Trinidad Express newspaper story that was published on February 21, the chairman of TTTI, Derek, was quoted as saying that, and I quote, "There are serious concerns about the level of corruption in the country, and much needs to be done to combat it immediately." Derek's concerns are by no means misplaced. In fact, he might as well have been referring not just to Trinidad and Tobago alone, but also to Jamaica, Ghana, as well as the entire Caribbean region and other developing countries. I say this because it is important for us to understand that although corruption is a global problem which impacts both rich and poor countries alike, the threat that it poses to developing countries is disproportionately severe, and if not checked, can potentially lead to state failure or even state capture. Indeed, it was Mr. Jim Young Kim, the president of the World Bank, who incisively characterized the gravity of the matter when, in December 2013, he put it this way, and I quote, "Let us not mince words. In the developing world, corruption is public enemy number one." Defined generally as the abuse of public office for private gain, corruption first and foremost erodes the quality of life of the citizenry by diverting public funds away from the provision of critical social necessities, such as health care, education, water, roads, and electricity. Corruption also leads to human rights violations, steals political elections, distorts financial markets, reduces investor confidence, as we heard today, increases the price of goods and services, undermines or destroys confidence in critical public institutions, and it enables organized crime, terrorism, and other threats to human security to flourish. But for developing countries such as our regional states here in the Caribbean, the magnitude of the potential for adverse socioeconomic consequences which corruption portends can be very substantial. Insidious in its very nature and in the way in which it operates, the threat of corruption for the Caribbean is foremost in its so-called grand form. We have heard of petty corruption, but this is in the grand forms. Bribery, kickbacks, embezzlement of public funds, cronyism, links between politicians and organized criminal elements, influence peddling, and the abuse of one's public office for political gain or to pervert the course of justice are but a few of its far-reaching manifestations which should be of concern to all of us in this region. Many studies have been undertaken in an effort to estimate the monetary costs of corruption in the developing world. The results are staggering. In its most recent report, which was released in December, the Washington, D.C.-based research and advocacy organization Global Financial Integrity said that the world's developing countries lost as much as $946 billion, almost $1 trillion, in 2011 alone, to corruption, trade misinvoicing, and tax evasion. Even more astounding was the revelation in January of this year by the Center for Strategic and International Studies, which equated private sector bribery in developing countries to a tax on growth, which it says is costing at least $500 billion a year. That's more than 3 times the total amount of foreign assistance that these countries received in 2012. Now, separate and apart from these studies, we have also recently witnessed vivid examples of the social upheavals and the consequential economic and political dislocations that can occur when emerging economies are afflicted with the perception of corruption and the abuse of state power. The Philippines, Turkey, Thailand, and most recently, Ukraine are all classic modern-day examples of this phenomenon. But coming closer to home, according to Transparency International, Jamaica, Trinidad and Tobago, and Ghana are currently perceived as the three most corrupt countries in the English-speaking Caribbean, having received CPI scores of 38, 38, and 27. Trinidad 38, Jamaica 38, and Ghana 27, respectively, in Transparency International's 2013 Annual Corruption Perception Index Survey, where, as you all know, 0 means that a country is perceived as highly corrupt, and 100 means that it's perceived as very clean. But the available historical data paints an even more damning picture, since it suggests that all three jurisdictions, again Trinidad, Jamaica, and Ghana, are marred in corruption that is perceived to be systemic. The data reveals that over the past 12 years, 22 to 2013, Jamaica and Trinidad have recorded an average CPI score of only 35 out of 100 for Jamaica and 38 out of 100 for Trinidad, respectively. While over the last 9 years, 2005 to 2013, Ghana's average has been only 26 out of 100. And I need to point out that the highest Jamaica's ever scored is 40 out of 100. In those days, it was 4.0. That was in 2002. And in that same year, Trinidad had its highest score, which was 49 out of 100. Ghana's highest score was 28 out of 100, which it received in 2012. According to the report, corruption was ranked as the most, not surprisingly, the perception that these countries are, and I quote, highly corrupt, is also supported by the World Economic Forum's most recent survey, the results of which are contained in its 2013-2014 report. And the World Economic Forum bring together the G20 countries as well as the investors from these developed countries. And this is a sort of a survey they look at to determine where they invest their money in emerging markets. And according to that report, corruption was ranked as the most problematic factor for doing business in Ghana out of the 16 factors against which 148 countries worldwide are assessed every year by that group. Whereas for Jamaica and Trinidad, corruption was ranked as the third most problematic factor out of 16 facing investors after crime and inefficiency in government. So that's what foreign investors are seeing when they look at these localities as investment possibilities. You don't come here. Although the adverse impact of petty corruption should never be discounted, much of the concern that there is about corruption in some of our regional states appears to surround issues of transparency, fairness, and probity in major public institutional processes, including contracting and divestments and the issue of license, as well as government decision-making. The view is substantiated in part, again, by the World Economic Fund survey, which on the factors of public trust in politicians, that's one factor. Another one is favoritism in decisions of government officials, which means that there's no level playing field. You have to bribe your way through. And another factor, irregular payments and bribes. Again, what they did, they ranked 148 countries, and Jamaica scored 113, 107, and 79. Trinidad 111, 125, and 95. And Ghana 63, 122, and 120, respectively, out of 148 countries. It is also undeniable that there is a rising sentiment from within the region, which is saying that the independent oversight of public procurement must be a foundation plank of any serious national anti-corruption institutional reform if probity, transparency, accountability, value for money, and competition in public contracting is to be assured. This is currently the case in Jamaica, where there has been widespread and sustained calls for a comprehensive revamping and strengthening of the country's entire anti-corruption institutional framework, but with a major focus upon public contracting oversight. And I'll speak a bit more about that later. We have also seen where leading and now incumbent political parties in Barbados, St. Lucia, and Bermuda have felt constrained to issue public statements of intent to establish replications of Jamaica's independent country of the Contractor General, in an effort to send a signal to their respective electorates that they are serious about combating corruption in public contracting. Curiously, the countries I mentioned, in Barbados, it was former, now deceased Prime Minister David Thompson who made that commitment. It was in January 2009, 1 year after he was elected to office, that he would establish a Commission of the Contractor General in Barbados. He died, as you know, the following year, October. It has not happened. In Bermuda, Craig Cannonier, the premier who was just elected to office in December 2012, in his manifesto, he said he would establish an Office of the Contractor General. And of course, Dr. Kenny Anthony, prior to getting into office in November 2012, in his manifesto, he also said he would do it. And you must remember this, because politicians will say they will do things, and when they get into office, it doesn't necessarily happen. But despite that, the fact is that commitments were made in these three countries. In a similar vein, at least one opposition political party in Ghana, the AFC, which is the Alliance for Change, as recently as February, repeated its call for the urgent establishment of a public procurement commission for that country. In fact, it went as far as to say that it would not support that country's efforts to put in place an anti-money laundering bill unless that procurement commission was first in place. At the recently concluded CARICOM Heads of Mission conference, actually Ghana was cited for not bringing its anti-money laundering laws on the books. Close to home in Trinidad and Tobago, considerable work has already been undertaken in developing and examining proposals for an improved national procurement regulatory regime. The process has been led by a joint select committee of Parliament with significant input from the Trinidad and Tobago private sector civil society group. I see many of the representatives here, as well as others. His Excellency Anthony Carmona, Senior Counsel, the President of the Republic of Trinidad and Tobago, who was one of my students, has also added his voice to the call for change when in his August 2, 2013 parliamentary address, he said, and I quote, "The need for legislation on creating a contractor general to address the issue of tendering procedures must be considered." Now, I know that Trinidad is not thinking about a contractor general, it's thinking of some other form of regulatory oversight body, but suffice to say, the President himself felt constrained to make a comment on the issue. Now, these varied expressions of a desire to craft new and more effective ways to combat corruption in public procurement in regional jurisdictions are key steps in the right direction, and they should be commended and they should be encouraged for expedited execution, because we're seeing where commitments are made, but we're not seeing where the action is being taken. In monetary terms, and one of the reasons for this is that there has to be an emphasis on procurement regulation. In monetary terms, the illicit manipulation of the award of government contracts and license, as well as the divestment of publicly owned assets, have long been considered to be possibly the largest opportunity that exists for corruption in any country, barring outright embezzlement and theft of public funds that we have seen in some African states and in the Philippines under the Marcos regime. Transparency International has estimated that based upon surveys at the country level, the cost of corruption in public contracting expressed as a percentage of the contract, the value of the contract, is an average of 10 to 25%, and in the worst cases as much as 50%. Now, when unscrupulous businessmen agree to pay corrupt public officials kickbacks for the award of lucrative state contracts, when public assets are sold below value to the friends of politicians, or when government contracts or licenses are tender-rigged and awarded to politically connected persons or to corporate entities in return for political campaign donations, it simply means that there will be significantly less public funds available to build schools and hospitals, to fight crime, and to provide for the much-needed public infrastructure and services, such as housing, roads, water, and electricity, which in many countries throughout the Caribbean region are today at substandard levels. In consequence, and although everyone in the society will suffer because of corruption, the most vulnerable, the poor, will suffer first and suffer the worst. And ultimately, and this is a key thing, the prospects for improving the socioeconomic plight of an entire country are at one and the same time summarily impeded, compromised, and undermined. As I had mentioned earlier, many within the region have come to regard Jamaica's Contractor General Commission, and I was privileged to be, serve in that capacity. They've come to regard as a gold standard for independent procurement oversight. Indeed, Belize has replicated the commission from as long ago as 1994. However, and I'm here to say this, and while the concept is a groundbreaking one with many useful and unprecedented features, which if strategically and dispassionately utilized can drive fair into the corrupt, the construct is nevertheless in some respects fundamentally flawed, and it is important that there's an awareness about this, and I'm going to talk about that. Now, it was arising out of the widespread public outcry about corruption in the award of government contracts that the Commission of the Contractor General was established in 1983 in Jamaica as an independent commission of Parliament, appointed by the Governor General, or as we'd have it here in Trinidad and Tobago, the President. Of paramount importance was the fact that under Section 5(1) of the Act, it sought to hammer home this issue of independence, and it's very important, by providing that, and I quote, "In the exercise of the powers conferred upon him by this Act, a Contractor General shall not be subject to the direction or control of any other person or authority, including Parliament." The only other provision we have like this anywhere in Jamaica is with respect to the Director of Public Prosecutions under Section 94 for a Constitution. So it was very unique in that particular respect, totally independent. The Contractor General was also granted security of tenure and security of compensation, and he was accorded with the powers of a judge of the Supreme Court of Jamaica and was thus literally insulated by law from any political maneuverings which could compromise his ability to carry out his functions in a fearless and dispassionate manner. At the core of his functions was his mandate under Section 4 of the Act to monitor the country's 200 public bodies in the award of Government of Jamaica contracts. Last year I left office, we're monitoring roughly 12,000 contracts, over $500,000 in value. And also license, we identified roughly 600 different classifications of license in Jamaica. Where's the license to mine for bauxite, or a license to mine for gold, or a license to become a hairdresser. And, but his job was to monitor these activities by the public bodies in Jamaica to ensure, and that's the term that was used, to ensure, and I'm quoting, to ensure, and that's very important, that they were awarded and terminated, and I quote again, impartially and on merit, and in circumstances which did not involve, and I quote, impropriety or irregularity. Additionally, the Contractor General is vested with a discretionary power to conduct formal investigations into a broad range of procurement-related matters, inclusive of matters that were associated with the registration of government contractors. As I mentioned before, to facilitate the effective discharge of his functions, he was accorded the powers of a judge of the Supreme Court of Jamaica, with wide quasi-judicial powers of inquiry, search, discovery, and subpoena. Included among his far-reaching powers were his entitlement to be advised of the particulars of any government contract award or license, as well as his authority, with few exceptions, to secure unimpeded access to any place, not just a public office, but even residences, any officer, public officer, person, document, record, information, or thing, which in his exclusive discretion he might deem to be vital to the discharge of his functions. Finally, to further reinforce the inquiry powers of a Contractor General, the Act made provision for 3 criminal offenses. 1, failure to comply with the lawful requirement of a Contractor General, obstructing a contractor general in the discharge of his functions, and making a false statement to mislead or attempting to mislead a contractor general. All these were criminal offenses. Later in 1999, via an amendment to the Act, a complementary National Contracts Commission was established to evaluate and to register government contractors. We have about 1,600 government contractors registered in Jamaica who are certified to bid on government contracts for the procurement of goods, works, and services, and to independently review and endorse all recommendations for the award of government contracts over a defined threshold. It's now over $500,000. You have to go through the National Contracts Commission. And over time, as well, the government procurement guidelines were also progressively strengthened. So with the Contractor General Commission, the National Contracts Commission, and your procurement guidelines were last amended in 2010 with supporting regulations which basically say if you breach them, that's a criminal offense. That's what we had as our procurement regime. With all of this, a significant change was expected in the manner in which lucrative government contracts were to be awarded in Jamaica. Probity, transparency, competition, value for money, accountability, impartiality, and regularity were all considered to be the key deliverables that would thereafter characterize Government of Jamaica contracts going forward. But I'm here to say that this was never to be. Because of certain structural shortcomings in the Contractor General Act regime, which is now over 30 years old itself, together with other deficits and loopholes which we identified in the country's procurement guidelines and processes, but most importantly, which were never ever rectified, either by the executive or the parliament. Because of that, the Contractor General regime, regrettably, has not been able to achieve its full potential. And there are lessons to be learned from this, and I'll speak about that afterwards. So, and I'll go through and I'll look at some of these structural shortcomings in the regime, which have never been fixed, despite repeated recommendations to the government, successive governments, as well as parliaments. Paramount among its major failings is that although the Contractor General Act, I mentioned it earlier under Section 4, expressly mandates a Contractor General to ensure, that's the word the Act uses, to ensure impartiality, merit, propriety, and the lack of irregularity in the award of government contracts and license. Nowhere in the Act does it give the CG the power to bring to a halt a government contracting or a license process which he has reasonable cause to believe is showing signs of impropriety, irregularity, or corruption. It's just crazy. You say to him, you take an oath, you must ensure that this happens, but you do not give him the tools to do that. So you get to a point where you begin to question the sincerity of Parliament. So consequently, despite the enormous powers of subpoena and investigation that a Contractor General has, in the final analysis, unless he's prepared to use those powers in a strategic, dispassionate, and aggressive manner, he's confined merely to filing reports, just to filing reports and making recommendations and referrals. And oftentimes he's making recommendations to the very objects of his investigation. To compound what I call this toothless bulldog or paper tiger effect, there has also been an almost systemic failure of the state's law enforcement agencies, and when I say the state's law enforcement agencies, I mean Jamaica, to act upon the formal referrals and recommendations that the Contractor General makes for either criminal investigations to be conducted by the police or for criminal prosecutions to be started by the Director of Public Prosecutions, or for other civil or administrative sanctions to be imposed. I served for 7 years, and I can tell you that I did 80 investigations, 40 of them were tabled in Parliament. I referred probably about 8 MPs, including ministers from both sides of the political divide. There's one who is currently on a trial for the last 5 years, Mr. Kern Spencer. I referred him back in 2008. The prosecution just closed their case, probably about 2 weeks ago. He was a state minister of energy. But essentially, nothing happens. The Corruption Commission in Jamaica, not the Contractor General Act Commission, the Commission for the Prevention of Corruption, complained in its last report to the Parliament, the 2013 report, that 77.7% of all matters that it is referred to the DPP has not yet been ruled upon. So, that's just some of the background, that I want to give you for the problems we have in Jamaica. And, when I get to the recommendations, you will see why we have the recommendations that we have to address those issues. A third shortcoming of the Act, the Contractor General Act, is that the sanctions that it imposes for criminal offenses have remained literally unchanged for over 30 years. The Jamaican dollar today is 108 Jamaican dollars to $1 US. As a youngster, I remember when $1 Jamaican dollar could buy you more than $1 US. And I'm here to tell you that today, the three offenses that I mentioned only on the Contractor General Act, the penalty, the criminal sanction, is a fine not exceeding 5,000 Jamaican dollars. That's 46 US dollars. And or 12 months in prison. The penalties for breaches of the procurement rules. I remember when I got into office in 2005, if you breach the procurement rules, it was neither here nor there. They were just rules, guidelines. So I advocated for them to be breaches to be criminalized. And Mr. Bruce Golding, who I have much respect for, he became our Prime Minister in 2007. And like the Prime Minister before him and after him, they made commitments about fighting corruption. And he said in his inaugural speech that he would criminalize breaches of the procurement rules. But he did it. He did it. But do you know what the sanction was? $1,000 maximum and or 3 months imprisonment. $1,000 is $19 US. 9 US at today's rate of exchange. 9 US. So yes, the breach has been criminalized, but that's what you have. Sir David spoke about stiff criminal penalties, and I'm at one with him. That's something I've preached for years, and I'll speak about that a bit more in my recommendations. Now, when you look at all of that, those deficits, to the detriment of the state, all of the foregoing, when taken together, would have emboldened the corrupt to act with impunity. Particularly since, and everybody does this, if you decide to engage in deviant conduct, psychologically, or, overtly, you're going to do what I call a risk-benefit analysis. Will you benefit from your conduct, or will the risk outweigh the benefit? So you decide that you won't do it. But any risk-benefit analysis of this situation would tell you that it's beneficial for you to engage in corrupt conduct. Because if the CG who is monitoring the thing makes a referral, nobody prosecutes, no sanctions are imposed, and if they catch you, you just pay $9 US. Another major deficiency of the Act, which was significantly diluted the independence of the Contractor General, is that he has no autonomy whatsoever over his budget. Remember, the devil is in the details. He's independent, but over here, the Minister of Finance controls his budget, his staffing, or other required resources. Sir David spoke about the TCI model, where there's constitutional protection, not just for the Integrity Commission, but also for the provision of their funds. And that's very important. And I have lived it. I remember I cited a sitting senior cabinet minister for criminal prosecution for having lied to me, which is perjury under the Contractor General Act and the Perjury Act. You're basically lying to a judge of the Supreme Court. And I referred him for criminal prosecution along with the permanent secretary and the contractor involved. And the DPP did not prosecute. And the minister in question was bold enough to say that they should amend the Contractor General Act so that I could not do that again. And I wrote a 9-page letter to all 83 members of Parliament and issued a media release and suggesting that their time would be better spent not in trying to find ways to dilute the effectiveness of the Contractor General, but rather to do the opposite and strengthen the capacity and the effectiveness of the office. But our Parliament, our House of Representatives, meets on a Tuesday morning, and the sitting government, for example, holds, I think 41 out of 63 seats. The Contractor General Act can be passed, can be amended any Tuesday to dilute the powers of a Contractor General. So it's very important that your governance structures, your regulatory oversight structures are entrenched and insulated from arbitrary political and government interference by putting them in the Constitution, as Sir David spoke about the TCI Integrity Commission. So, perhaps, ladies and gentlemen, if I am to put it succinctly, in summary, the single overarching reason why the Jamaica Contractor General regime has failed to fully secure its objectives, the objectives for which it was established, is a lack of political will. I could speak 2 weeks straight on this subject, but I probably have 10 minutes left to go. So, but political will is the issue, political will. And there's absolutely no question about this in Jamaica. And I've said this repeatedly. This is not something I'm saying in Trinidad for the first time. I've said it over and over in Jamaica. And I say this because the proof is in the pudding. You've heard of ISO 9002. And you design a quality system and you audit it to find loopholes, deficiencies. And then you come up with root cause, you do a root cause analysis, and you come up with corrective actions or remedial actions. You implement them and you audit again to make sure that it's working. And if you do that, theoretically, eventually you'll have a 100% complete good quality system. That's what I did at the OCG. As I found a problem, I made recommendations to fix it. Whether it's an issue having to do with accountability, lack of transparency, lack of competition, lack of fairness, something which you could not get value for money. You make recommendations. The weak penalties, you make recommendations. But the people to whom you make the recommendations to, despite the statements that they make on the political platform, that they're going to combat corruption, they're going to change the nothing has been done. And so that is my proof of the pudding. So what I'm saying here, thank you, thanks, is that despite these recommendations, nothing has happened. And we've made recommendations to remedy the aforementioned deficiencies and to strengthen the effectiveness of the Contractor General regime. Made recommendations to significantly enhance transparency, value for money, competition and accountability in public contracting in Jamaica. We've made recommendations to strengthen the Jamaica anti-corruption institutional framework and also to generally win the battle against corruption in Jamaica, but all to no avail. There are therefore crucial lessons to be learned from all of this, for it is important to recognize that the lack of political will can manifest itself in the creation of state anti-corruption mechanisms and institutions which are intended by the political directorate to appease its domestic and international stakeholders, but which in effect are facades or will over time prove to be dysfunctional, as we have seen in Jamaica. Such structures are easily identifiable, and you must look out for them. While on paper they may look good, upon closer examination they will be found either to be structurally deficient, flawed in construct, ineffective, inefficient, weak, lacking in teeth, lacking in critical resources, and are led by political implants that are there to do the bidding of the political directorate. It happens. Once something like this is allowed to happen, the effectiveness of the state's anti-corruption institutional apparatus will be undermined, and the institutional mechanism in question will run the risk of being rendered literally useless. Regional states that are interested in designing effective, independent national procurement, regulatory, and oversight anti-corruption regimes are therefore encouraged to be mindful of the foregoing. And you're also encouraged to give careful consideration, where appropriate, to the following remedial anti-corruption recommendations, many of which I have already formally advanced in Jamaica. One, and this is because of Jamaica's own circumstances. We have 3 corruption commissions: the Integrity Commission, you have one here. We have the Contractor General Commission. We have the Commission for Prevention of Corruption, which is a deliverable under the OAS Treaty Against Corruption. My recommendation, which I made back in March 2010, has now been accepted. Pretty soon, this week, next week, we should see something in Jamaica. We're the first in the Caribbean. And what it is a single anti-corruption state agency with special resources, merging those three institutions that I just spoke about, but having exclusive criminal investigation and exclusive criminal prosecutorial jurisdiction. Investigate and prosecute as well, first in the Caribbean, and full police powers of arrest and detention over all corruption offenses. Sir David told us about the developments that we've had in TCI, where that commission has the powers of arrest. I've made similar recommendations here, but to go one step further to give them prosecutorial powers, and that is because of the unique Jamaican situation, where offenses against a person takes precedent in the court. Jamaica has one of the highest murder rates in the world, and everything is focused on that, but not on corruption. We have a backlog in our court system of 400,000 cases. So if you're serious about fighting corruption, you can't just look at the issue of the police won't investigate or the DPP won't prosecute. You have to fix that. We also have to make sure that when you get to court, you can get through. So another one that I have is establish a corruption court to adjudicate all corruption-related offenses. Or if you don't want to do that, you can do what they do in Sierra Leone, which is to give priority to corruption cases in your prevailing court system. So that comes first along with murder and capital offenses. Everything else, you join the line. Another one, if you don't want to go the route of merging into one single one, you want to have an independent thing like a contractor general, do it. But, ensure that it has the power to halt a proposed award, which is exhibiting signs of impropriety, irregularity. If a building is going up in Port of Spain, you must have a building plan. And if an inspector comes and sees it's a 20-story building, if you get to the second floor and you're not doing it right, they can tear it down. It's the same thing. It should be the same thing with a regulatory oversight body. If you're saying you're there to ensure that corruption doesn't take place and that person sees corruption taking place, that body should have the power to stop it, or then it makes no sense. And that's what I found. I know how to come up with ingenious ways to drive fear into the corrupt rather than just stopping the process when I see it. Another recommendation, coming, another 5 minutes. Strengthen and enhance the independence, whatever you have in place. If you don't want to do those things, strengthen and enhance independence, effectiveness, accountability, and competence levels of existing anti-corruption institutions, regulations, monitors, investigators, and prosecutors, and take all requisite measures to insulate them from government, political, or third-party abuse, direction, or interference. Again, put the thing in the Constitution. The whole thing doesn't have to go in, but it has to be protected from the people who you're monitoring. 5, impose significantly tougher criminal sanctions. I have proposed in Jamaica minimum mandatory custodial and economic-based penalties for corruption and all corruption-related offenses. They haven't done it, but I think that's what we need to do. We need to send a signal to the corrupt or those who are inclined to be corrupt that if and when we catch you and you face the courts and you're convicted, you're going to serve for a minimum period of time. Legislate standards, $9 won't do it. Legislate standards of integrity and good governance conduct for our politicians and public officials. We don't have that in Jamaica. And enforce same via impeachment or recall provisions. We need to say to our politicians, this is absolutely the minimum standard of ethical conduct that we'll allow you, or standards of governance. In Jamaica, we have found that our politicians, the conduct that they get away with, in other countries, they've been in prison, they've been jailed. And, the citizens, they get to a point where they just see it as nothing. And we need to, I think, legislate minimum standards of conduct and ethical behavior for those who are in public life and enforce it. Continuously review anti-corruption laws. We make the laws and then we don't look back at them. I spoke about the Contractor General Act, which was promulgated in 1983, and people have gotten smarter. The corrupt have gotten brighter. They've gotten bolder. and we have not revisited the laws to see what we should be doing. So continuous review anti-corruption laws to cauterize loopholes, criminalize new developments in corrupt behavior, and elevate existing sanctions where necessary to deter unwanted or deviant conduct. Establish a national public register of corporate beneficial ownership and legislate appropriate political campaign finance laws. We've heard about that. But the corporate beneficial register of beneficial or human ownership is very important. That's, I've found as Contractor General that you see ABC Limited getting a contract. When you go to the registrar of companies to search who the human shareholders are, you see another list of corporate entities. When you go to the next level, those corporate entities are registered offshore. So you don't know if it's I am the one who is behind the company, or the Prime Minister, or the leader of the opposition, or a judge of the Supreme Court. This is now, the European Parliament has just voted that they're going to have public registers of beneficial owners. That should be very useful for us here in this region, because you follow the money. If we have corrupt people in political life who are taking bribes and hiding it overseas, you will now find out. The Cayman Islands, following the cue from Mr. David Cameron in England, has just also announced that they're going to have public registers. Implement a national system for the decertification, debarment, and cross-debarment of a government contractor. In Jamaica, we register government contractors before they can bid. And what we're saying is that if they perform poorly or if they're engaged in corrupt conduct, you come up with a system where you decertify them. They can't bid again. They're not qualified to bid again. In my last year in office, I decertified 80 government contractors. And that's why I have a lot of people. I guess I have an X on my back. But we decertify them for making fraudulent representations on their applications to secure certification. So a contractor who probably got $300 million in government contracts the year before can't get any government contracts again. And under the World Bank system, you have what you call cross-debarment. If, for example, the World Bank debars a contractor who was working on a World Bank finance contract, it's cross-debarred with the Asian Development Bank and other development banks around the world. So they can't get any more. They can't get any more contracts. Impose tough criminal and civil sanctions upon the private sector entities. Sir David spoke about this, for the bribery of public officials, and require them to develop, implement, and enforce company-wide anti-bribery compliance programs. I can't say anything but repeat what he said. This is the supply side of the corruption problem. We're always focusing on the public bodies. The private sector has a major role to play in this. And what is now happening is that Brazil, in January, they just had a new Anti-Bribery Act. And if a Brazilian employee for a Brazilian company, well, it could be a janitor, it could be a director, it doesn't matter. If that person bribes a foreign public official or a public official in Brazil, the fine that is imposed upon the company is as much as 20% of the gross annual revenues of the company for the year before. 20%. This is a very serious matter. That company is then forced to deploy anti-bribery compliance programs right across its employees to make sure it doesn't happen. We need to start doing that here in the Caribbean. Impose added sanctions inclusive, I'm on the second to last page, penultimate page. Impose added sanctions, and it's bold print, inclusive of the imposition of term bans from office and forfeiture of pensions in the case of public officers who are found guilty of corruption or breach of prescribed good governance or integrity standards. They can never come back into office. A lot of countries have this. You're banned for 10 years from public office. We're seeing it in Italy with the Prime Minister who was just charged. You can't come back into office. And finally, require the public filing and disclosure of annual statements of assets, incomes, and liabilities for all parliamentarians, politicians, and critical level public officials. In some of our countries, we're required to file them. I file them. In Jamaica, the body with over $2 million has to file it. But it's not public. It's not public. And I'm saying make it public, because then you can see the differences in the asset levels and the income levels of the people who are in public life. You may say that you're getting into their personal business, but that's the price you pay to get into public service. You're spending people's money, so they have a right to know what's happening. Ladies and gentlemen, as I had said some years ago while addressing another regional conference on corruption, corruption is a crippling, corrosive, destructive, and evil vice which we can ill afford to take root in any of our regional jurisdictions. The World Bank has found that there's a 400% governance dividend, or a fourfold increase in per capita income, like 2,000, 8,000, that a country stands to gain by just deploying stringent good governance and corruption controls. Fourfold increase in per capita income. Additionally, the bank has also said that the private sector enterprises will grow significantly faster, on average by as much as 3% more in annual growth, where corruption is low and property rights and the rule of law are safeguarded. The bank's assessments have been corroborated by other studies that have similarly estimated increases in growth at the national level of between 2 and 4% in instances where corruption is controlled, and has compared the cost of corruption to a 20% regressive tax that foreign investors face when they come to your country to invest. It is therefore abundantly clear that in fighting corruption, we have everything to gain and nothing to lose. So I implore you, and by you I mean the government, civil society, private sector, your international development partners, the multilaterals, let us join hands and be more aggressive and collaborative in our efforts to combat the cancer of corruption, which has already undermined our trust in many of our national institutions, which is inhibiting some of our regional countries from attaining their full socioeconomic potential, and which, as we have seen, has already seriously tarnished at least 3 of our states in the eyes of the global community of nations and investors. Thank you very much.